was living a lie. In the darkness, I was scared of the light. With no direction, I was running away. Step aside, enjoy the ride. Enjoy the ride.
Well, I'm so thankful that Judge Oleski is here with us today. There was a time when we didn't have judges deciding family issues. There was a time when divorce, you would just go to the legislature and get a piece of paper and you'd be divorced, just like you go to get your marriage certificate, okay? So we keep having to remember that. And I think I gave you the history, and it'll be in your materials of court, and how our mission is to eliminate court for families. And what does that look like? Because we've grown up with court, family court, divorce court, judges deciding important issues like abortions for children. It looks like family innocence. It's what it looks like. It looks like what we do. And so this is, we have a few cases going right now that are, I call them pure FIP, okay? So family innocence, the end, it's a one-stop shop if you're getting a divorce, okay? And as I've told you, many of our people come and they end up not getting a divorce because of the way we facilitate the communication between the couple. What did you hear him say? Is that it? Is there more? The dialogue process that we do, and we consistently have the couple talk to each other. And ultimately, sometimes they don't get a divorce. We had a mediation this week, and that's why it's so exciting that it happens to be Judge Oleski is involved today. The end game of family innocence is if you're mediating, and remember, it's restorative circle mediation, almost purely facilitative. We do all the work in the mediation, and I've been an attorney in mediations with Judge Oleski. He does it the same way. He does all the work like right then and there. As far as I know, he doesn't say, well, I'll go draft something and spend a few hours outside of the room or and get you something 3 weeks from now. We do all the work there, and I feel that's very important because I've been asked, can't you just draft this up as a mediator? And I say, no, we'll just do it together. And it actually saves time, ultimately. But in the family innocence process, all of you who are going to be advocates and restorative circle practitioners, in the family innocence process, if the couple reaches impasse, okay, on 1, 2, 3 items, and you recognize that they are stuck on 1, 2, 3 items, we have what's called a decision-making process. And we have a roster, and Judge Oleski is on our roster. And we have some attorneys, learned in the law, are on our roster. We hardly ever get to that place because most of the time when you're in an impasse and you're saying, okay, we're in an impasse, we're going to send you to another person to make a decision, most of the time it kind of turns into kind of a mediation arbitration kind of thing, we call it, where you're mediating and they haven't made the decision, but they might ask you to say, well, to weigh in on it. We don't normally do that. We'd ask the judge, the retired judges to do that piece. I wanted to tell you the very first time it happened where the couple had reached impasse for their divorce. They didn't have kids. They had a lot of wealth. I finally convinced the other attorney to go to our decision-making process. Now, here I am, the founder of Family Innocence. I'm asking another attorney who's representing somebody else to do so, and he happens to be involved in a lot of our mediations now. And he finally trusted me because we were all ready to go to trial. We had our boxes. Each client had probably spent thousands of dollars on each of us, and the judge couldn't make the judge wasn't available. We had 4 or 5 cases ahead of us. We're ready for trial. And I said, please, let's just go to this decision-making process. So he agreed, and we went to Judge Aldridge. And after that process, where we were just going because we had reached impasse, that attorney sat down and said, this is the future of family court, what we're doing right here. I mean, Judge Aldridge was smoking a cigarette outside with the husband. We were making phone calls and getting it done instead of waiting till the next quote hearing, next session to actually get a document or something like that. And we ultimately, the decision maker, Judge Aldridge, was making the decision. It was a very comfortable environment, and they said, you make the decision, Judge. And I think it was a bedroom set or something like that, a very expensive bedroom set. And the judge said, well, I'm awarding it to the wife. And the wife said, I don't want it anymore. Why don't you award it to him? I really don't feel like moving it or something like that. So ultimately, we get a decision, and then both of them end up. And if you've ever seen kids fight, I call it the mine, yours, where, they have a toy. Mine. I remember my kids. Yours, mine, yours, mine, yours, mine, yours. Recognize as you're doing this that that's what's happening. Mine, yours, going back and forth. So what I'm going to do now, and then we'll get back to Judge Oleski, is part of our process when we had a circle, and I'm going to put it up on the board. I have the family court process on the board right now, which is very hairy. It's not as streamlined as it seems. You don't get to a judge until the end. A lot of times it settles. That's why mediation is so very, very important. And maybe you want to speak to that, mediation being so important. Mediation was probably invented, it's always been around, but probably became more formalized about 45 years ago. And I remember when I became a Rule 114 qualified mediator about 25 years ago, I said, oh, this is the wave of the future, and people didn't even know what mediation was. You'd have to explain it. And that is still the case. People don't know what mediation is. They know what court is, but they don't know what mediation is. So maybe you can speak to that a little bit while I set up for the next exercise.
Mediation became much more formalized. I want to say that the courts adopted it sometime in the last 10 or 15 years that they would not allow civil cases to go to trial unless the case was mediated, with the exception of medical malpractice or legal malpractice cases. So everybody else had to go to mediation, and family court certainly had it. So family court is probably much more of an advocate of mediation than even the civil courts, because a lot of times they won't let you bring issues up post-divorce, after the divorce is final, unless you go back to a mediator, back and forth. Well, the question is sometimes it's really expensive, and how a lot of these families are just stressed financially to do it. But I found that mediation, I went to the same thing that Michelle did. I think, is anybody else 114 qualified here? Okay, you know it. So it's like a 30-hour course I think we took. And I took it over at Hamlin University. And I was struck by, I had already started becoming a mediator, and I decided I'd get to 114. And they said they wanted everybody at the beginning of the mediation to get together in the same room. And then the mediator would kind of talk and say, introduce himself or herself, kind of talk about the process, kind of talk about the issues they're going to try to resolve, maybe spend 20 minutes up to 45 minutes talking. And then sometimes would ask the lawyers, because invariably their lawyers would be there with their clients, and then the lawyers to make what they call an opening statement or just present the issues, with the hope that the lawyer would do it in a neutral thing. It didn't work. The lawyer would become a strong advocate, attack the other side, the strengths of their case. So I did this about 3 times, and I said to myself, this is crazy. I'm not going to do this unless both parties agree to it and that they agree to not to be to do it in a neutral setting, saying these are the issues, this is what we'd like to resolve, and not attack anybody. But I didn't trust the lawyers, so I have come to the conclusion, and I've done about 15 to 2,000 mediations, and I've come to the conclusion I'm not going to let that happen. So I always meet with the people separately, and I kind of only talk for like 5 minutes. One lawyer told me, he said they had another mediator judge, and he talked for an hour and a half about his qualifications and all his work, and he said, I'm paying this guy $300 an hour so he can brag to me about how great he is. So I try to be very brief, just do it for about 5 minutes, lay out the ground rules, tell them that they can always talk to their lawyer, caucus separately with their lawyer, that whatever they want me to be confidential about, I'll keep it confidential. I won't tell it to the other side, and that I can't be forced to come to court, that everything we do here is confidential, and I'm. It's like I always say. Remember that ad which goes to Las Vegas, stays in Las Vegas. I said that's what happens at mediation. So I try to get it on that status, and I try to impress upon people a resolution to resolve these things. And I keep telling them that you're the one who can make this decision. You're the one that has the absolute ability to decide what's going to happen. I said, if you can't do it, you're letting a neutral party do it, some third-party judge that you don't know, that's overworked, has got more cases than he or she can handle, and you're asking that person to do it. Now, would you rather have that type of person do it, or would you try to resolve it yourself? And try to give them the emphasis to do so. I don't want them to leave. So I'll keep them there. I've found that most mediations got to go 3 to 4 hours at a minimum. I don't know how you feel about that. And I've had civil mediations go 16, 18 hours, but my theory is then you wear them out. And then, okay, whatever you want, I want to go home and go to sleep, and I'll sign whatever you put in front of me. I remember...
Not our process, Pat.
I remember I did a mediation.
But it's tempting, I'm telling you.
I remember I did a mediation. You were talking about this couple had gotten divorced, and they had resolved the custody issues, but they were a very wealthy couple, and they had an enormous amount of paintings, very wealthy paintings and statutory things that they'd purchased in Europe, etc., and they couldn't decide who was going to get it. So they hired me to be the mediator, arbitrator, to figure it out for them, and we would meet, and I would say, and they must have had about 25 to 35 very valuable paintings, and I'd say, tell me what you want, and they would each list the same thing, and I say, well, would you trade this for that? And no, and they once we were meeting in a restaurant, a bite to eat, to discuss a little more procedure, and an issue came up on child visitation. They got in this terrible argument, and I said, I don't want to get involved in this, and the wife left, and the father said to me, thank God she left. I was just going to take this bottle of ketchup and pour it over her head. And I said, she would have called the police, because she did that once before, and you'd be back in jail again. So I said, I'm not going to ever meet with you folks in a restaurant again.
Oh my goodness.
There you go. We'll be talking about a domestic abuse later on in the program.
So anyway, I finally said to them, here's what we're going to do. We're going to flip a coin. And whoever calls heads gets first choice. And then the tails person gets second and third and fourth. And they did not like that, because they thought, they were going to lose out. So I said, well, then your decision is letting me make the decision, and I'll tell you who gets what, or you guys decide. And they finally sat down and decided I tried every stratagem in the world to get them to do that, and I think when I told them that I was going to make the decisions, be the arbitrator, and I said, I don't care. I said, I have to tell you something. I don't know anything about art. It means nothing to me, and I know it's very valuable to you because you put a lot of time and effort and expense in getting this, and you could just walk through their houses and just see all the art that was there. They were going to sell the house too, by the way, so they had to take it out. But anyway, so sometimes they'll ask you to be in an evaluative position. They say, well, Judge, what do you think should happen? Who do you think should get visitation or whatever it is? And so, but a lot of times I try to do that at the end if there's an impasse. It's something called a mediator's recommendations, where you can go at the end and say, here, you tell them each separately, here's my recommendation. Tell me if you'll accept it or not. And if they say no, then it goes away. And I don't tell the other side that the other side's accepting it, only if both people agree to it. And obviously they can figure it out and they say, okay, we'll take your recommendation. And then if the other side says no, they know the other side has turned it down. And sometimes you just get an impasse back and forth on it.
Right.
It's and I think it's very important, and you'll learn that too, or you have done it, to let people talk, because there's a lot of times they come into mediations with a lot of anger toward the other party, and just be a sounding board back and forth. Now, some lawyers tell me they don't like judges because they think judges. I was telling Louisa, judges have what they call black robe disease. That judges are used to making decisions and being very preemptory. In fact, there was a retired judge who's now deceased that he would wear his robe at mediations, and for that authoritative thing. I never do that, but in most people don't. But so some lawyers just don't like judges because they feel judges tend to be too authoritative, arbitrary, and want to make decisions. But I found that let people talk it out, let them go back and forth, give them a time to. So I find like the first time I meet with, if I'm meeting with one side, usually you spend maybe half an hour to 45 minutes with them, and then go to the other side, and then once you can then start narrowing some of the issues down, then things accelerate and get moving. I don't know if that's what your experience is, but
Right. Would you agree then it's all about being heard?
yes,
It's all about being heard.
exactly.
Yep.
People want to be heard. They want to have somebody acknowledge their position, lend some credence to it. Even if you don't agree with them, you just can't say, "Boy, are you wrong?" I also try to point out to people, how expensive litigation is, and I say, if you want to go forward with this matter, it's probably going to cost you $15,000 to $30,000 to try this case. Can you wouldn't it be nicer to take that $30,000 and put it in a fund for your kids, or take a vacation, or do something with the money, and instead of enriching this guy sitting next to you?
And I think what I'm hearing too is the attorneys get in the way, and we have a process where the attorneys kind of stand by if they're there and let the clients talk with each other, and even the clients. The couples don't talk with the mediator. They do and they don't, because they use the talking piece so they get to talk with each other. I find that attorneys get in the way. I also find that the mediators can get in the way, because we have our judgments, and you had just said sometimes they ask the mediator, what's your thoughts? That's your judgment. You have to kind of avoid that almost at all costs, because you're going to have judgments and you're going to have thoughts. And you're going to say, why don't you just do this and get this whole over with? But it has to be between the two of them, and mostly they have to hear each other. Another thing is the judges get in the way. They really, really, really do. I remember we finally settled this case, and we had everything settled on custody and every single conceivable parenting time, and the judge was up there, and we had all of the holidays set forth that they had agreed to except for one. And the judge said something like, well, what are you going to do about Christmas Eve and Christmas? And started another big, bringing up something that wasn't even an issue for them. And that was just one thing. One thing brought up could just get them back into that mode of arguing. So our process is to get out of the way and to not rush things, which is very, when you have a legal mind like mine and a judge mind like Judge Oleski, and even a mediator, after you've done these a million times, you'll be just like, why don't we just do this? You just have to be patient and just let them do it.
Yeah, I just did a mediation involving a couple where they bought a house before they got married, and they split up before they got married, and the question then became who's going to get custody of the house and the equity in it, and I just said to him, the man had put the money for a down payment, and he made a gift to her on it, and he signed some papers making it a gift because I think he was trying to get disability. So and she was saying no, he gave me the money, and I said, well, you ended up putting the the down payment that he gave you on the house, and you shared it, and I said, you know what? I said most judges are not going to agree with that he doesn't have any interest in that house. I think he's got an interest in the house, and I just said this is what I think is going to happen if you go to court in that evaluative thing, and we eventually resolved it. But so sometimes I'll say what I think a judge is going to do, etc. Sometimes I'll find where lawyers don't let their clients talk, and they just make all the decisions. And every time they want to talk to their clients, they ask me to leave the room. I hate that. And I get to the point saying, I don't really think this thing is really going to work out because you've taken so much control of it, and you want to run the whole show. And
Judge Oleski has been a mediator on many of my cases, and I do a lot of different types of cases, not just family. And he's very good. And I stay out of the way as an attorney, so I'm good about that. But I remember one case, the client was very stuck, not wanting to pay anything, and it was a civil case, insurance, things like that. And we had our experts, and we were just raring to go. And and he was getting a settlement. My client was all of a sudden going to pay quite a few thousands of dollars and I'm thinking, wow, to this insurance company. I'm thinking, wow, I got to stay out of the way. Whatever he was doing in the other room with the other attorney, I was talking with my client, but he wanted to do it, and he did it. So I had to stay out of the way, and Judge Oleski was really good about staying out of the way, at least in my room. He did definitely say how costly it is going forward, and it would have been. So people do have to start to think of the cost benefit. In family, it's a tragedy sometimes, the money they spend and lose hundreds of thousands of dollars.
As a divorce judge, I remember hearing a case, and I think the attorney fees were over $300,000 for the couple, and it was just unbelievable. One of the other things I try to, if things aren't really moving so well, I sort of will say to people, well, let's imagine the worst and the best case scenario. Now, the best case scenario, you go to court and you're going to prevail, and you're going to get everything you want. Now, let's take what the worst case scenario is. You're going to lose custody of your children. You're going to pay a ton of maintenance. You're going to lose the house, whatever it is. And let's take those things into consideration and see if there's some medium compromise we can make along those lines. And sometimes it works. I just did a mediation. It had nothing to do with it was a landlord-tenant situation. and I was explaining to the tenant how much it was going to cost to fight this case, because they were claiming constructive eviction. She was claiming that the landlord had rented it out to a masseuse parlor and a bra fitting place, and she didn't like all the people coming in, and they were making so much noise, and I was trying to explain to her how much it's going to cost, and she said, "You know what? I'm a very wealthy person, and I don't give a darn. I'll pay my lawyer $50,000 to try this case." So my theory of expense didn't seem to work on that one. So you gotta know your audience.
Well, what we're talking about.
So noisy.
What we're talking about here is the different models of mediation, and we're creating a new model with our class, and it's the restorative model. Okay, I realized that as we were going forward. We have the evaluative model, which is you're evaluating the situation and putting forth your judgments. We have the facilitative model, where you're facilitating a settlement. We do it by the parties, the dialogue process, the peacemaking dialogue process that we do with the couple or with the whole family, if that's the way it's working. Then there's the transformative process, where it just all of a sudden a light bulb goes on, and they kind of become transformed. And then the narrative process that Judge Oleski was talking about, where you're just going to tell your story, and then the other person gets to tell the story to the mediator, and then the mediator kind of might evaluate and make a decision or learn, but you're always talking to the mediator. And again, in our process, you're always trying to get them to talk to each other. Even sometimes when they're talking to each other, they'll be looking at each other, and they'll say, "He said this," and "he's saying that," and not even, and I'm like, use his name or say "you." So you're always directing them that way. Lori's nodding her head because she's now knows. And then the anatomy of a mediation. Our anatomy is the same as regular old mediation. I mean, the anatomy, and this is all in your materials already, is, you introduce the process. We do that with a phone call and the orientation, that you'll have the PowerPoint, that you'll be able to tell them what our process is. We call that an orientation. Sign agreement to mediate, that's the second step. We have a participation agreement, a very simple one for circle, a very elaborate, a little bit more elaborate for divorce and family. And you have those in your materials. And then you do the agreement to mediate. We have that conversation as the third element. We do the listening and the facilitating. We always do the be still moment, and then the listening exercise with everybody. And we're going to demonstrate how that worked in a recent one. And then agreed actions for the next session. We write an agreement, but in our process, it's agreed actions. What are we going to bring to the next when are we going to have the next meeting? Are we done yet, kind of a thing? And it's we try to keep those very, very simple and have everybody sign. And usually the facilitator will say, "I'll be there at the next meeting to help facilitate." We even have our own offers. So any thoughts on that, the different types? And I think you're doing all of them at once.
I think it's kind of important to make people comfortable. So sometimes it's good to go to a neutral site rather than one lawyer's office or the other. So I have conference rooms at my office. So I always make sure there's water, coffee, candy. Where the restrooms are very important to people. And to take breaks and to get food. Because I can't tell you how many mediations go over the noon hour and they'll say, would you like food? No, we're going to be through shortly. And the next thing is 4:30 in the afternoon. Half the people are angry or hungry, and that kind of manifests. So I've learned to keep a Jimmy John's. They're great. I mean, they deliver. Or if there's a right by my office, there's 3 restaurants right outside. We're on the Skyway in downtown Minneapolis, so there's food available at all times. Or you can get Jimmy John's if you go too late, or Domino's I've had too. But in any event, that helps. I think when people eat and they can relax and and bring some of those things. I recently did a family matter, a couple in their 50s, their children were grown, and it was mainly a financial issue, and they neither of them had lawyers, and somehow they ended up with me. And we went back. We met about 3 different times in a facility, and I was like a facilitator, and we discussed, pensions and splitting up of assets and selling the home, and how much maintenance would be given, and at the end, what we did is, like Michelle mentioned, we said, okay, we've agreed to these 5-6 steps, and what happened, I would then send an email out at the end to both parties and saying, here's what we agreed upon. Let's next meet in 2 weeks at my office, and we should talk about the following issues or what other issues you want to bring up. And we did about 3 times. We finally agreed on something, and we worked everything out in a very collaborative means. But I found that with some of the issues, they needed time to digest it and think about it. And I think one of the sides had a financial advisor that she was talking to, and I think she needed to talk to that person between those sessions to see if what I was saying and what she was agreeing to was something that their financial advisor worked out.
And in our process, we'd invite the financial advisor to the circle, so they could actually be in the process.
We kind of talked about that, but the financial advisor said, if you want me there, you're going to pay me a bunch of money.
That's true.
Okay. Yeah.
So in our mediations, and I don't know if we've talked about this a lot, we set aside judgments, right? But we do get to gossip a little bit or talk about how we feel or felt about the mediation, because we have co-mediators, co-facilitators, plus an advocate who's kind of making sure they have their coffee and that things are copied and that the tables are all set up, and they're just the host of the family, and they're and we call it not neutral, but we call it multi-partial to everybody. But neutral is kind of, because you do have partialities, but you try to be multi-partial. When do I let them argue and when do I grab the ball?
I dropped something on the floor and I realized there's nobody to pick it up, and I had to pick it up.
Humpty Dumpty can never put the egg back together again. And
They go to another attorney, and the other attorney says, I can get you more.
That bike is sexy. Growing up, I was living a lie. In the darkness, I was scared of the light. With no direction, I was running away. I tried to cover that I'm losing my mind. Now it's over. I wonder, yeah. A new beginning, it's a new way of life. Another chapter, why not give it a try? This hopeful journey needs an open mind to discover the treasure inside. Now I'm sober. Summer, until you open your eyes. Never see the truth until you look past the lies. Mother Nature is waiting for you to arrive. Step by side, step by side, enjoy the ride. Yeah, yeah, yeah. Do, do, do. La, 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 la. Enjoy the ride.
So Michelle is going to leave us with the Family Innocence theme song. We know it's going to be catching on everywhere. So take it away, Michelle.
And I won't have my husband Tom sing with me this time.
You guys are all blessed.
Okay. Camera. Start spreading the bird, beginning today. We want to be no part of it, the family court. The bird is the word. It's flying away to make a brand new start of it. No family court. We want to wake up in a household where we can sleep instead of fearing a judge ready to peep. These family court blows are melting away. We will get to the heart of it with no delay. If we can do it here, we'll do it everywhere. No family court, no family court. One more line. If it is not a crime, we are not doing time in family court. No family court.
Hollywood, here we go.